Good morning, everyone. Myself Akshay Padwalkar, and topic for today is jurisdiction of civil court under the Civil Procedure Code. In this video, we are going to see what are the provisions regarding the jurisdiction of civil court under the Civil Procedure Code, and what are the some relevant case laws which have interpreted the scope of jurisdiction regarding the jurisdiction of civil court. When we look into the jurisdiction of any court, first we have to understand what is the concept of jurisdiction. When we see the meaning of jurisdiction, the term jurisdiction is not defined expressly or explicitly under the Civil Procedure Code. However, the word jurisdiction is derived from the words juris and dicto, which means I speak by the law. In simple words, jurisdiction means the power of court of law, the power or authority of court of law to hear and determine the cause or matter. In the case of Raja Soap Factory versus SP Shantharaj, in this case, Honorable Supreme Court held that jurisdiction is an extent or authority of the court to administer justice prescribed with reference to the subject matter or pecuniary value and local limits. Now, going further on jurisdiction of civil courts under the Civil Procedure Code. Section 9 of the Civil Procedure Code provides that civil court has jurisdiction to try all suits of civil nature unless their cognizance is expressly or impliedly barred. Now, there are two explanations provided under this section. First explanation is that a suit in which right to property or an office is contested is suit of civil nature, and there is no matter whether that such right may depend entirely on the decision of question as to religious rites or ceremonies. Now further, second explanation provided under this section, which was added by 1976 amendment of the 1976, which provides that for the purpose of this section, it is immaterial whether or not any fees are attached to the office referred to the in explanation 1, or whether or not such office is attached to a particular place. Therefore, now when we see the section 9 of this Civil Procedure Code, we notice two conditions. These two conditions clearly mentioned under these sections are: the suit should be of civil nature. The suit must be of civil nature. And second condition provided under this section is the cognizance of suit should not have been expressly or impliedly barred. Now, how to determine whether any suit is of civil nature or not? The word civil has also not defined under this code. Then how to determine nature of suit? It is not status of the parties to the suit, but subject matter of the suit determines the nature of suit. For example, when subject matter of the suit consists private rights and obligations of citizen, then such suit can be called as suit of civil nature. For example, there are some examples of suits which can be called as suits of civil nature. For example, suit relating to right to property, suits relating to right to worship, suits relating to damages for civil wrongs, suits relating to suits for specific reliefs, suits for rents, suit for right to franchise, suits for dissolution of marriage, and also suits for restitution of conjugal rights. These are some examples of suits which we can say as the suit of civil nature. Now, in another case, most Reverend PMA metropolitan case. In this case, Honorable Court held that the term civil nature is wider than the term civil proceedings. Now, for example, in section 9 of the CPC, this section would therefore be available in every case where the dispute was of the characteristic of affecting one's right, which are not only civil but of civil nature. It means that the section 9 is not limited only for the matters which are only in civil, but this section applies to the such suits which has of the nature which civil nature. Now there is another case, Sinha Ramanuja versus Ranga Ramanuja. In this case, a court stated that a suit in which a right to property or an office is contested is a suit of civil nature. A civil nature, even such right may depend entirely on the decision of question as to the religious rites or ceremonies. Now, second condition to determine the jurisdiction of court, a civil court under this code, is such cognizance should not be barred expressly or impliedly. Now, there is one case law, Humrao Singh versus Bhagwati Singh. In this case, Honorable Supreme Court stated that a suit is said to be expressly barred when it is barred by any enactment for the time being in force. Now, what is meaning by suit impliedly barred? A suit is said to be impliedly barred when it is barred by general principles of law. For example, where specific remedy is given by a statute, there is implied that the such specific remedy deprives the person who insists upon remedy of any other form than that given by statute. Now, in another case, Premier Automobiles Limited versus Kamlekar Shantaram. In this case, court said that where an act creates an obligation and enforces its performance in a specific manner, that performance cannot be enforced in any other manner. Now, there is one question arises that who may decide the jurisdiction of whether any court has jurisdiction in any specific matter. There is one another case law for that is Bhatia Cooperative Housing Society Limited versus DC Patel. In this case, court held that civil court has inherent jurisdiction to decide its power or its jurisdiction in any matter. Now, there is further one case law which is Phamset Radhakishan versus Administrator of Municipal Committee Ludhiana. In this case, the court said that the mere conferment of a special jurisdiction on tribunal in respect of a said matter does not in itself exclude the jurisdiction of civil court. The statute may specifically provide for ousting the jurisdiction of civil courts. Now, consent. Now, there is another principle regarding the jurisdiction of civil court. It's consent can neither confer nor take away jurisdiction of civil courts. And this there is one case law, further one case law is A.R. Antule versus R.S. Nayak. In this case, Justice Mukherjee stated that any court by its direction could not confer jurisdiction on the other court to try any cause for which it did not possess. Further, in this case, Justice Mukherjee stated that the power to create or enlarge jurisdiction is legislative in character. Therefore, any court cannot create such power, and only Parliament alone can do it by any law and not court. Now, there is one case law. There is Dhirendra Nath versus Sudhir Chandra. In this case, Supreme Court said that if the court has not inherent jurisdiction, neither acquiescence nor waiver nor estoppel can create such jurisdiction in this regard. Now, after seeing all these case laws and provisions, we can summarize some general principles regarding the jurisdiction of civil court. First principle is that civil court has jurisdiction to try all suits of civil nature unless their cognizance is expressly or impliedly barred. Now, the second principle is that consent can neither confer nor take away jurisdiction of a court. Third principle is that a decree passed by a court without jurisdiction is nullity and the validity thereof can be challenged at any stage of the proceeding or even in collateral proceedings. And fourth principle is that there is distinction between lack of jurisdiction and irregular exercise of jurisdiction. Another further principle is that every court has inherent power to decide the question of its own jurisdiction. And sixth principle regarding this jurisdiction of civil court is that jurisdiction of a court depends upon averments made in a suit, in a plaint, and not upon the defense made in a written statement. And another seventh principle in this regard is burden of proof of exclusion of jurisdiction of a court is on party who asserts such exclusion of jurisdiction. And another one key principle in this regard is that for deciding jurisdiction of a court, substance of matter is very important and not its form is not important. And I think I have tried to summarize and explain very important provisions and important case laws in this regard. And for today, that will be enough, and we will meet in further video. Thank you.